Welcome everybody. Good evening to the Chartered Institute of Arbitrators London Branch joint event together with the LCIA, the London Court of International Arbitration, which is very generously been hosted by Quadrant Chambers. And we are here, the in-person audience at least is in their wonderful library. And we welcome, of course, also our online audience. Great. Right, now another serious topic. We're talking about what happens when the arbitration proceedings have been hacked. And that is, according to surveys, 90% of all law firms and parties involved and stakeholders involved in arbitration think 90% think that it's a very serious and important topic and that needs to be addressed. However, it is a very small percentage comparatively who actually do something about it. I know, of course, the law firms try to make sure that their IT system, etc., is very secure, but it is also obviously the parties that are involved, it is the arbitrators that are involved, counsel is involved, institutions are involved, and it's not just the law firms that are involved. So everybody has to do their bit to make sure that arbitration proceedings will be as safe as possible. But I'm afraid to say reality is you can't prevent this. It's just not, there is no 100% remedy not to be hacked. So we just have to be mindful and aware of it. And the London branch, we've covered this topic already last year as well in June 2021. But because we felt because it is such an important topic and we need to raise a greater awareness and the mindset of cybersecurity, but not only cybersecurity, also a topic that is close to Ruth's heart, about illegally obtained evidence. And last time we've already mentioned illegally obtained evidence when I mentioned the Brazilian pulp case, which was an ICC arbitration. And one of the parties, how should I say, organized it, or that they hacked one of the solicitors of the other side, their emails, and they obtained a lot of their privileged information and used it in their pleadings in their arbitration. The other side found out and said to the ICC, but they found out after the arbitration award had already been published, and they said to the ICC, I'm sorry, but they should withdraw this and reject the award, and in fact the arbitral proceedings should start again. The ICC has decided, no, I'm afraid they've upheld the award, but interesting enough, the Brazilian courts have state the enforceability of that award. So there is a lot going on in that topic, around that topic, and I'm just very pleased that we have such a distinguished panel with us today, and that we represent as many stakeholders as possible. And of course, if I first of all like to welcome Jamie Harrison, who is the Deputy Director General of the London Court of International Arbitration. We've posted all the bios of the speakers online, but I think, Jamie, you have also, because you've been a solicitor also in various jurisdictions, so I'm looking forward to hearing also perhaps your experience, not only from the institutional perspective, but I'm just very glad that we also have somebody here and to represent the institutional perspective, because that's quite key as well. Because I don't know whether you've heard or seen, when surveys are there, probably 30 to 40% think that it's actually the arbitral institutions that should take responsibility for cybersecurity. So we're looking forward to hearing your side on that. So welcome. Then on the other end, we've got Robert Maddox. He is a member of the Debevoise and Plimpton Data Strategy and Security Practice in London. Welcome. And I have to say that we are particularly pleased also to have you here as the rising star in cyber law by Legal 500. So your opinion and your experience is very valuable, I'm sure, to our audience. And Ruth Hosking, thank you, Ruth, because Ruth is one of our hosts here from Quadrant Chambers. She's a barrister specializing in international arbitration, in shipping, commodities and commercial arbitration. And Ruth is a star because she was one of the, in 2018, I think one of the leading, or the leading shipping junior. And she is mentioned again in the Legal 500 as shortlisted as Junior of the Year for 2022. So fabulous, thank you. And last but not least, one of our own from our London branch committee, of course, Shobana Iyer from Swan Chambers. And Shobana is particularly affiliated also with technology, IP rights, and she also sits on various committees covering topics like that, including the Bar Council. So fantastic. Thank you, Shobana, for also being here. And I think now it's probably time to dive in. And diving in means we'd like to hear from the audience as well. Are you aware whether any of your arbitrations have been hacked? Who would like to go first on this? Jamie, would you like, as an institution, because it's obviously quite a tricky one as an institution,
yes,
to get that out of the way?
Yeah, I mean, I guess on the basis that we probably have the most of anybody, the greatest chance is. It is enormously rare for us to be aware of an arbitration that we're administering that has been hacked. I'm sure we'll come on to this as an issue. That part of the problem is that very often you don't know you've been hacked. So the number of cases that we're aware of is very small, and as far as we're aware, the hacking does not take place at LCIA HQ or through LCIA HQ or our systems, but very often through the parties or arbitrators. And the only notice we have of it is when we receive a fairly generic email from generally Barrister's Chambers saying we're aware of a hack. We're aware of a number of files that have been the target of or within the scope of the hack, and the case number X falls within that scope. We're not aware that anything is out of order, but that is really all that we hear. And as far as I'm aware, I've been with the LCIA 3.5 years. We've seen that twice. I think it's quite interesting, and again, we may come on to this. Quite interesting that we've heard that from surprisingly large sets of chambers, and perhaps their systems have improved over the last 2 or 3 years. But I think from your perspective as arbitrators, I think I've often been encouraged, I think, by arbitrators who are looking for appointments who come from perhaps from larger chambers or from groups, from law firms, etc., where you hope that issues of cyber security or data protection or whatever are part of the sort of institution that they come from, and that's sort of quite encouraging from our perspective. It is then slightly counterintuitive that the big hacks that we've seen have come from the big sets of chambers, which may be a more obvious target, maybe a more obvious sort of shop front for a hacker who's looking for interesting stuff and may not be targeting this particular case. So perhaps the one-man band, the Gmail in his spare bedroom is actually better than the big. It's better than the big sets of chambers.
Yeah, because actually you're raising a myth there, which we have to unveil. Exactly, fabulous. We will get to that. Shobana, what is your view? Have you ever experienced it, or are you aware of it, or have you suspected anything in your arbitral proceedings you've been involved in?
Not directly, no. I don't think the majority of these cases, and particularly now, you're going to be able to, the way that the cyber security system has really kind of increased in the complexity of it, is now it's becoming more from ransomware attacks to kind of spyware attacks. So it's very difficult now to even know whether you're being hacked. So I would say, no, I don't know whether being hacked, but you've got to really think about, and exactly like what Jane was saying here, really look at what the purpose is. There's kind of like 3 categories of kind of hackers in a way. They're the activists who are there for some kind of social or economical cause or whatever that might be going after your arbitration. And then there are the criminal hackers who are there for trying to get some kind of lucrative money or some matters in that sort of state. And then also, of course, the state hackers who are actually doing, and that comes more into the ambit of like investment arbitrations, as we know, where we've done, you know, the South Seas China case where an institution's website, the Permanent Court of Arbitration, got hacked into. And then, of course, you've got things, and the other one that's quite open because they're investment arbitrations that are well known, is the Libanco Holdings Corporation versus Turkey, where the Turkish government managed to get information about legally privileged information between counsel and the party, but they managed to state to the tribunal that they actually got a Chinese wall put in place, and the arbitral lawyers in the arbitral proceedings don't have any information about that, but that was to do with money laundering investigation, which they're going up to. So you see a lot of these hacks that are coming in, and it really depends on which area. Why I say I look at that is because then you really consider, well, wait a minute, why have they targeted these lucrative top commercial chambers or top commercial firms? I think it's mainly to try and find out that information with ransomware attacks, etc., in that way. But I think further, there's going to be more complexities on this. And of course, we know well the government is actually going to be doing another survey on cyber resilience. So keep an eye out for that in the coming future.
Yeah, very good. Thank you. What about you, Ruth?
Not to my knowledge have I had an arbitration that's been hacked involved either as counsel or as arbitrator. I have seen other illegally obtained evidence, which we'll obviously come on to later, and a lot of the principles that you apply when considering that, you would apply equally sort of hacked information. And what you tend to see in that context is whether something's, from a hacking perspective, is whether it's come into someone's possession because someone else has hacked it, so a sort of WikiLeaks type thing, it might be in the public domain, or whether someone has deliberately gone out and asked, Reuters, for example, has done quite a lot of work on this, quite a lot of scary work, I might say, where they have found particular investigation companies have used particular Indian hackers, particular group of Indian hackers, to go and deliberately target certain people to go and get stuff for particular litigation, and that's been used in that way. So I haven't seen it, but it's definitely on the rise and it's out there. And I think it's something that as a community, we will need to pay much more attention to than we currently do.
Yeah. Robert, what do you think? Especially, I've just read a statistic from the Solicitors Regulation Authority that they say at least sort of law firms, 75% say they've been victim of an attack.
I mean, look, it doesn't surprise me, because I think all organisations have been targeted, and with the best will in the world, some of those who are targeted are going to become victims of a successful attack. I mean, to the original question of am I aware of arbitrations that have been hacked, I think it's worthwhile thinking about, well, what do we mean by that? Because my answer would be not arbitration proceedings specifically, but I know of at least a few examples of managed service providers who have been the victims of attacks that were used in conjunction with arbitration proceedings. But was the arbitration being targeted? No, not really. It's, you know, it's collateral damage, I think, in most cases would be my supposition on that.
Yes, because who would you know? Because arbitration supposedly is private. Who would know which party has started arbitral processes against another party, which law firms are involved, who the arbitrators are that are appointed, under which institutional rules will these be conducted, or is it ad hoc arbitration, and who to target there? So that must be quite specific. And I guess, as you say, it's probably coming out then from phishing from law firms, because it's they have, prior to the pandemic, law firms have actually been one of the prime targets of hackers internationally. And only because of the pandemic and the vaccine research, etc. So research labs, especially the medical industry, has been overtaken by the legal industry. So it is sort of, we are definitely one of the prime targets. And the question is, of course, also who is the weakest link here? And is it, as Jamie has mentioned, a one-man band, or is it in fact a greater law firm because with many more employees who are, you can't control them all, or the training sticks better with one than the other, who would actually react or fall in trap to one of these phishing. And it's not just emails, it's also text messages. It's now, and I see that also on WhatsApp or any of the other Telegram, any of the other chats.
We've had a very good example of this recently, having said that we don't see it very often. It is something that's happened recently where I think probably exactly that has happened, that somewhere within the ambit of the parties and the arbitrators and the firms involved, or the experts, the people that do know who's involved, we were aware that an email had been sent within a chain of emails between all of the parties and the arbitrators that came from casework@lcia.com. Any of you that use us a lot will know we're .org, but casework@lcia.com seeking payments of deposits for future costs. I mean, it was very unlikely that we would fall for it or that anybody would fall for it, but we spotted that pretty quickly. So that's a classic phishing scam. It doesn't happen very often, but that is certainly, from what we're saying, that comes from within the sphere of the participants, as opposed to just a random collateral situation.
Yes, and then the question is exactly how will we know that we've been hacked? That's a really difficult one, I think. And as I say, it could, for example, in the Brazilian pipe case, only because the other side used it in their submissions and their pleadings. So the other sort of the solicitors thought, hang on a minute, this is privileged information. Where did they get that from? Or with WikiLeaks, I thought it was interesting that they then said, is it admissible or is it not admissible? Because WikiLeaks, in fact, is a public domain, even though it has been criminally obtained, so to speak, through a security breach, and it was leaked. But everybody had then access to it. So it's quite a deep topic, which we could probably talk about a lot and for much longer than an hour and a half today. But I think it's a question, sort of, if we know if a breach has occurred. Robert, with you, obviously, as a law firm, I guess, which I also understand, in fact, cybersecurity is one of the growth or the prime growth area for law firms. Mm-hmm. What do we have to do if we're hacked?
Yeah, so I mean, look, it's a global issue, and then you see a global proliferation of breach notification laws, principally focused on exposure or unauthorized access to personal data, which trigger mandatory notification obligations to either regulators, data protection authorities, and or individuals whose data may have been exposed. So I think you've got this growing legal framework that after an incident then needs to be tackled in terms of working out, or who do you need to tell in terms of regulators and individuals, and how do you go about making those notifications. I think from the UK perspective, one observation that I would have is that the UK regulator, the Information Commissioner's Office, is pretty light touch, frankly. If you notified them about the exposure of most personal data that is exchanged hands in the context of an arbitration, they're not going to be particularly interested in it in most cases, I would imagine. So the most likely outcome is often that you might notify the regulator, but you hear very little back beyond an acknowledgement, and that they're not going to take any further action. But there could be different circumstances, of course, that might make a regulator take more notice of it. But that would be my gut in most cases when you think about the personal data that is actually changing hands during proceedings. Some parties operating in different sectors, so financial services is highly regulated. In those cases, you might actually have notification obligations to the financial services regulators that they fall under the ambit of. So you've got to think about what data is actually at issue, and therefore who you might need to be telling about it from a legal, regulatory, but also contractual perspective. If, for instance, a dispute relates to contractual terms that implicate a third party, there are sometimes breach notification provisions in underlying contractual documents as well. So those are the three sort of areas that I would advise people to consider.
Mm-hmm. And have you ever had an arbitrator asking for advice because an arbitrator said, help, I've been hacked? Perhaps not necessarily in the arbitral proceedings which are going on, but in general?
I've not, no. But I mean, going back to one of my earlier comments about what do we mean by the arbitrations being hacked, and obviously I said about, well, actually, I think a lot of the time it's collateral damage. I think you could also look at the question from the arbitrator's perspective. Arbitrators are individuals at the end of the day, and the proportion of us that will have some form of our passwords used either currently or previously having been exposed and available on the dark web is extremely high. The question is that password still valid? And I think is something that I've mentioned when I've spoken previously. I've not seen people yet do it. To me, at least, for the most sensitive arbitrations, a natural part of arbitrator due diligence could be trying to ascertain whether an arbitrator's personal details are available on the dark web, because it could pose a risk either due to unauthorized access or, depending on the nature of the material, risk of blackmail and the like against an arbitrator. So again, just some things that aren't often spoken about but are worth considering, I think.
Yes, exactly. They're not spoken about. Jamie, have you had an arbitrator contacting you as an institution to say, help, I think I've been hacked?
Not an individual. No, not that I'm aware of. As I say, we've had groups of arbitrators, but not an individual.
Interesting. And maybe also from our online audience and here in person, if you have the feeling, if you like to share that with us in the Q&A comments or anything, that'd be welcome, because I think it concerns every single one of us here. So it'd be really interesting. And as Robert has said, we don't really speak very much about this. Ruth, do you have any thoughts on that?
Not particularly. I think one of the things is that firms and large sets of chambers are obvious targets. And so I think it's more unlikely, unless it was a hack that was deliberately being done by somebody as part of a litigation dive, like the old dumpster diving that people used to do. There was a man that used to go and look in people's bins who ended up in prison. It's sort of the technological part of that now. I don't think a particular individual arbitrator will necessarily be targeted because it's not well known. I think what's quite interesting in the context of thinking about cybersecurity and arbitration, lots of people want the institutions, for example, to host documents and things, but I would have thought that would have just made them a massive target for a hack, because all the data, the hacker would know that all the data would be held, not necessarily the privileged communications, but all the other data would be held at the institution's server or whatever, whereas they sort of have to guess a bit if they're trying to do it with firms. And I think certainly my experience from friends who sadly have been subject to hacks is that it's a ransom that they want to be paid. It's not particularly targeted at any individual arbitration. It's just we've got your data and we won't give it back to you unless you pay us some money. So.
Yes, or we've even received these kind of emails that they say so, but it's not actually the case.
Yeah.
So read this very, very carefully and make sure you read also not just what it says the email is from, but actually click on the email to find out, because then you actually find who it's a real sender of the email, which is a lot of the times just a number and then something. So be aware of that and always make sure you click on first that you really know who sent that email, because typical is what we've seen now is every time, for example, the London branch has a new chair and we put that on our website, all of a sudden there's an email that is pretended to be sent from the new chair to the committee members, which are visible on there. And we've had that for the LMAA. I know that's very similar as well. I don't know whether you've had that also when you've had for your officers, but they say, please contact me immediately, and things like that. And it's very easy. They are so cleverly phrased now that people think, oh my God, the chair is saying I need to contact him or her immediately. So they do so, or they act upon it. So be mindful, again, check is that really from that person or is it not from that person? Shobana,
I mean, just on that point there, I'll just mention that check who you're actually is your service provider when you're hosting, because particularly certain host providers, you'll probably find that they're not that secure. And so even though sometimes even Gmail is better than some of the other kind of hosting providers, and in that sort of scenario, you can find that they can actually even hack into it and send emails with your full details in it. So you don't even know that it's anything different, mainly because they managed to hack into your host server on that point. But I would sort of say that you've got to think about the full ecosystem, and where you say that, okay, the main targets are like lucrative chambers and law firms. If they know that there is an arbitration going on or something like that, and they know who the arbitrators are, then they might find that the weakest link is to go after one of the arbitrators and stuff. And there's so many guidances out there to try and secure yourself as much as possible. But
actually, is there so much guidance? Because I've actually only found 2 cybersecurity protocols. One is from the ICCA and the New York City Bar Association is one of them. And then, of course, the Chartered Institute of Arbitrators have got guidelines on that. But I also know, Jamie, you've included that in your new rules, haven't you? The cybersecurity, at least part of it, addressing cybersecurity.
Yes. I mean, it's interesting that you started the seminar with the statistic of however many percentage it was that thought it was down to the institutions to manage this situation. The bottom line is that certainly as far as the LCIA is concerned, that we're very clear in the rules. The 2020 rules, Article 30A, is very clear that it is the responsibility of arbitrators and the parties to agree between themselves measures to protect data and information to ensure that the proceedings are secure, and that they should do that at an early stage, and that's very clear. And apart from that, the LCIA does not really expect to get involved in those issues really at all. We, I think, take the view that it's very difficult for us to produce guidelines on issues such as data protection. We're often asked, do you have a standard form data protection policy or protocol that arbitrators can deploy in LCIA arbitrations? And the answer is that we don't. And we don't because no 2 arbitrations are the same. And particularly with data privacy, you know, the identity of the parties is always different. The identity and location of the parties and of the tribunal, of any experts and any witnesses. Governing law is often very different. The seat of the arbitration is different, and the moving parts mean that trying to produce a sort of standard form of those kind of things is very difficult. And so we don't. But we're very clear that it is the responsibility of the arbitrators and the parties to do that as early as possible. There will be new guidance for arbitrators and for parties, which is in its sort of finalisation form, which will update the current notes, which you're probably all familiar with. But we do give some examples of what we mean by information protection and data privacy, and what you should be doing about it. And it is the sort of measures that we're talking about, and we give some guidance on encryption and file sites and all that sort of stuff that parties can deploy. But essentially, I'm afraid it's a matter for you to agree with your parties.
Yes, and it's because cybersecurity and GDPR are very much interlinked, but it is not just covering your data protection, but cybersecurity, and therefore that's what I also mean with these specific guidelines. There aren't actually that many out there, and I have to confess, this is a little bit advertising, but there's a non-profit organization called CIARb. CIARb.com, the website, where I have to confess, yes, I'm one of the founding members of it. But where you can also find templates of, for example, for procedural order for cybersecurity. We've now been asked, CIAC has very closely worked with us on issuing a cybersecurity protocol. We've had other institutions have now come to ask us to work with them to help them along. But the question also then is, and as I say, this is all free information available, completely non-profit. But the question then is, how much do we have to make everybody aware? Should the arbitrators issue a procedural order right from the beginning in arbitrations? Have you come across any of those? What do we do, Ruth?
I've not seen anyone issue an order immediately off the bat. I have seen arbitrators at an early stage, and I, as an arbitrator at an early stage, have raised with the parties when considering the first procedural order whether they've considered issues of cyber security, and if they haven't, I've sent them away to go and think about them, not so that they can necessarily come up with an agreed wording, but that we can then have a discussion about what we're going to put into place. And the reason I'm not sure it's necessarily appropriate to issue something off the bat is that not, as Jamie said, each arbitration is an individual arbitration. And so you as an arbitrator do not know what infrastructure the parties or the parties' legal representatives might have. You don't know what they can and can't do. And so I think it's much more important to have a dialogue, but raise it and put it on the table, just so that, if the worst does happen, at least you feel that you've all made an effort. I think what I find quite surprising is that when I've been approached for to see whether I'm conflicted, for example, or available to accept an appointment, no one has ever once asked me, what do you have in place? What cyber security do you have in place? And I think maybe that is a question that people need to start asking a bit more.
I have recently suggested that as part of the disclosure process and the sort of pre-appointment process, a good question would be, are you computer literate? Which I think is quite interesting.
What does that mean?
Exactly. But I mean, those are broader questions, and I would endorse that. I also think, of course, that's part of the nomination process too. That if you have potentially have an arbitration which may involve these sort of issues, if they're in a sensitive territory or they're in have sensitive issues involved, that there is a potential for it to be hacked, you might bear that in mind in nominating.
I think the point you raised there actually about territories is interesting, right? Because you've also, if I was advising clients that operate in certain jurisdictions, I would, just commercially operating in certain jurisdictions, I would say, you've got to understand that the government will have access to the data that you store and process on a day-to-day basis. And then there's, realistically, that's no different to if there was an arbitration involving a party in one of those jurisdictions or a third-party service provider in one of those jurisdictions. And it's not that there's necessarily a hack taking place in the way that people are thinking about it here. It's just about what rights do certain governments have to access companies' data that operate within their jurisdiction.
Very good. And have you come across procedural orders just covering specifically cybersecurity or addressing it as part of a procedural order?
Part of procedural order, pretty light touch. It was very similar to what you were saying actually about parties were invited to consider the issue, parties went away and considered the issue, came back with some pretty light touch, but still relevant high watermark measures that they wanted taken. One thing that I sort of beat the drum about is if you're going to do one thing, implement multi-factor authentication, that's it. I think that actually takes you a long way. It doesn't get you all the way there, of course, but if you're only going to do one thing, I would do that.
Very good. And Shobana, what do you think? What's your experience on that? And then also leading to the next question, who should be responsible for it?
Right. Well, I mean, with my experience, just going back first on regarding guidances, etc., we have the Chartered Institute's framework guideline on the use of technology in international arbitration, which actually assists in just having the kind of basic background, which I know very well Ben was the chair of, but it actually provides you the kind of basic requirements. And I think also, which I would recommend everyone to do, is to go to the National Security Centre, NCSE, is Cyber Essentials. There's a self-assessment tool that you can just make sure that everyone does that, because I think with today's world, you can do the basic kind of knowledge test on an assessment, whether you're a sole practitioner or whether you're in part of the firm, they're all meant to be there. There are also other kind of frameworks, as we see in the Iyer and the New York Bar cybersecurity protocol. And actually, there's going to be anybody who's going to go to the Iyer Congress next week. We're having a lunchtime meeting on Monday, so if you're there, do come along. There's the IBA's cybersecurity guidelines. We at the Bar Council are part of the IT panel, and we do guidances, and that's principally in line with what the Chartered Institute have put down in their guidances. But you can access it, regardless of the fact that they are the Bar Council guidances, etc. Everybody can have access to it. It's on the Bar Council's ethics portal, so you can always download some of those kind of basic guidances on travel, particularly with the international nature of arbitrations. When you're traveling on through airports on free Wi-Fi, make sure VPN is put in place. Some kind of compliance protocols that you can actually put into the schedule at the start of the initial preliminary meeting, I think is required, and I think is essential now. And we can see that growing in action with all the protocols. So when you're doing everything else on data protection, and as I say, one of the main concerns when you're doing outside of the EEA on data protection, I think you're looking also with regard to what's a security how can their servers be compromised, etc., and have that. And I think it's a duty of everyone. It's not just a burden on one person, one part or one constituent of the arbitral proceedings. I think one of the things that you have to do as part of your team, if you're counsel, if you're in the legal team, is to actually check your own camp up first. Find out about what witnesses you have, which jurisdictions they are, what are the cybersecurity laws in those jurisdictions, because they're very different as well. And then when you're going into the arbitration, or just as the arbitrator, about how are these proceedings going to be dealt with. If you're going to choose an arbitrator who isn't very tech compliance in that area, you know that, and you're willing to go ahead with that, well, see how you can support them with proper data sharing mechanisms, etc. So I think you need to have someone in the team to make sure that you can actually give that assistance to the arbitrators if the arbitrators haven't got that kind of knowledge and choose to have those kind of, because they're very expertise in that particular field. But with regard to IT cases, etc., where you're having very strong trade secrets, and especially source codes and stuff like that into the technology of it that you don't want disclosed, etc. I think it's very important that there's more care taken with confidential information, etc., about what you share, how you separate the essential sharing information with the other information that you might have on, and how you can actually deal with the arbitration in that way. So I'd say everybody in the ecosystem is responsible, but which proportion, it really depends. And I think you need to have something in the protocol to see about what happens when a breach happens, because I think it's like a virus. You need to find a way to try and stop it getting infected in the rest of the other cases that you might have, or the other kind of data that you might be able to.
Jamie, any comment to that? You have already sort of raised, I guess, the perspective that why should the institution be responsible for it? Exactly. It should never be just one stakeholder. But I guess institutions can't just say, no, I'm sorry, we are not responsible.
I think our primary responsibility is obviously to make our own systems so that we're not a part of the matrix of potential hacking. And that is very difficult. We have a relatively small organisation and 700 odd active cases. So it's quite difficult to protect that infrastructure, but we do take it very seriously. We invest in it. And I think that's our primary responsibility. I think what happens in the context of the arbitration is best managed by the parties and the arbitrators. Who know the particular circumstances and, as I say, the issues that arise in relation to where the potential entry points are for hackers. I think they have a much better means of controlling it. I can understand that there's a view that the institution might take more interest. I'm not sure, practically speaking, how we could do that other than to to maintain our own systems securely.
Obviously, there's also sort of a nouveau sort of trend that says institutions should provide an online platform administering the entire arbitral process, etc. Would that be safer, or would it not be safer? Would it, because that would then, of course, be a prime target, because then you can access all the cases at the same time, and you can get everything. On the other hand, I've heard from ethical hackers and from cybersecurity IT firms, coding or creating these platforms is actually much safer. So it's a very controversial topic, isn't it?
It is, and it's something obviously that we are considering, and we're investigating, and in particular investigating how secure it will be. There are a number of considerations, not least that not all users want to make use of that facility. The focus for us at the moment is an internal case management system, which will be launched on January. I was going to say January the 1st. That's probably not very likely. Or January the 2nd or 3rd. But and that will improve our case handling internally, and that allows for an updated portal on which you can register your claim and pay your fee, and that is, I think, probably more secure and better set up than it has been before. But in terms of an external portal, that's another very big step. I think it's quite telling that the major institutions haven't really done it. I think the SEC is still battling on with theirs. The ICC gave up, I think, with theirs. And it is something that we look at. The feedback that we get from users, particularly from big law firms, is that they would prefer to rely on their own cybersecurity measures when dealing with their clients' confidential materials, and provide to us as little as possible, for fear that somewhere between them and us, hack will take place, or that data will be lost or shared. And I think until we can reassure users that they are safe to deposit everything they have onto our systems, it's very unlikely to happen. The other thing that is quite interesting is when you stray into this area, and it really isn't my area at all, but when you talk to the people who provide it, and for example, the firm that is doing our internal case management system, what they actually seem now to want is to create a platform onto which parties deposit their documents, and that platform then passes through into the proceedings themselves, so that then becomes the means by which you serve each other with your evidence, or you produce bundles in the old sense for hearings, and you work during the hearing with source material. All of that would be one streamlined process from the moment of registration through to the delivery of the award, all on that same platform. And that for us is quite a big change. It's quite a big change for our secretariat. There's an issue about who pays for that service. And in particular, I think it really depends on how secure that is going to be. So the simple question about a platform has rather morphed into a much bigger conversation, because that's really the business that these people seem to want. The people who are sophisticated enough to produce it. So I think it'll be a while, to be honest, before that happens.
Yeah, interesting, isn't it? Because I know there is an initiative, and that's been going for a few years, and they've got such a platform now. Not all the facilities are there yet, but also where, for example, arbitrators in the end could all jointly write the award on that shared document platform as well, with everything and sending notices, etc. The idea is there, but as you say, it is actually much more complex, and the greatest issue is everybody's concerned about the safety and protection from a hack. And that's where Robert said exactly the multi-factor authentication. That I know they're looking at sort of at fourfold, etc. But it's difficult. But Jamie has thrown the ball to you, basically, Robert, also saying the law firms want to rather have their own document repository they control.
I mean, look, most large law firms vet all of their third-party IT service providers, and I think if an administering institution moves into the space of hosting data, you become a third-party IT service provider in the eyes of large law firms, and you will go through the same procurement process. The issue that causes, of course, is it's not a normal procurement process because you're not really a service provider in the traditional sense, but that's where you start straying into, and an institution would then be faced with answering diligence questionnaires, and it's not a light process. Entities that provide these services on a commercial basis have teams of people that deal with those questions and those questionnaires on a routine basis. An institution won't have those resources readily available to them. So I do think that it could actually introduce friction into the process that maybe doesn't actually need to be there.
And then the question is, of course, because Ruth, as counsel, do you have any control over what platforms to be used, how to protect it? Because by then, when you come in, the process is already in motion.
I'd like to say thankfully not. So I haven't had to give any advice on that. Different clients will also have different, underlying clients will have different requirements themselves. Certain big businesses will have certain levels of security, and then that is what solicitors firms take into consideration when they're finding what hosted platform I get sent documents on. No one actually ever asks if we can accept it. They just assume that you can. And so I sort of think even if an institution came up with a really good platform, there's no guarantee that every client, underlying client, and every user of arbitration would say, yes, that meets our own due diligence requirements. And given also that arbitration is a consensual process, I sort of think a lot of it, party autonomy is talked about a lot, but it actually is fundamentally hugely important. So I'm not sure that, I don't know whether Jamie will be relieved to hear this, I'm not sure that having an institution host platforms is necessarily the way forward. Even from a security perspective, or just the practicality of getting the arbitration moving.
And how much are you vetted by law firms as Chambers?
The answer is I don't know. As a Chambers, we all have to do cyber security training that's quite in depth. And I know that, for example, we have various sort of phishing emails sent to see whether you fall for any of them, and they are happening all the time. Apparently, touch wood, I have not had one where I've been told off. Apparently, if you fall for one of them, someone comes and tells you. And so that seems to me to be quite a good thing, because it keeps you on your toes. You're always aware that your emails, your work emails, could have something in them that there shouldn't be there. But no system is 100% perfect. So there's always that concern that something will get through.
Yes, and Shobana, because your Chambers are one of the smaller ones,
It's just
but it's
a sole practitioner.
Yeah, so it's the responsibility falls solely on you, like also solely on me as an arbitrator. But how do you handle that, and what would you recommend to the
Well, I
audience?
still comply with everything else that the larger Chambers does, and what Ruth was saying is exactly what happens. And I know very well, because of the compliance measures that solicitors have to deal with their clients, there was a complete burden on Chambers to actually go through all these tick boxes, say yes, we're compliant on that, yes, we have VPNs in place, we've got training in place, we have XYZ in place. And what the Bar Council did was have questionnaire security guideline now done with the Law Society, which is available, and that checklist gives you the kind of requirements that are usually required to have a secure kind of data sharing between barristers and solicitors. And one of the things that we have to know about is the fact that barristers, we're all self-employed, and regardless of the fact whether you're in a big chambers or you're on your own, we are data controllers in our own right, and therefore we take full responsibility as well for any of those kind of data leaks, etc. So yes, now chambers are having these kind of security compliance training, etc. annually, and every chambers have to check up on wet things. I mean, I think it's much more easier for me because one, I'm all right, I'm in the field, I know about it, I can do the checks quite clearly. I just have 2 clerks which have got a certain level of data which they can only use and on particular systems, and that's it. So they don't have access to the rest of the other information. So it's about actually how you secure your data and your infrastructure in place that assists. But I think what would really help, I think particularly with regard to arbitrators, etc., is just look at some of these guidelines, because I think they do actually assist in terms of what do sole practitioners or what do mediators actually can deal with in this field. And this is one thing I think I like to pass an area of training, because yes, the Bar Council is trying to make cybersecurity training much more essential. But I do feel that actually maybe this is where the institutions can come into place and probably help with training all their arbitrators. So I'm going to
because the question is, have you ever come across or have you ever recommended to an arbitrator? Is there any arbitrator cybersecurity training available for arbitrators, or should in fact institutions encourage them to do so on a regular basis or something? Or
I can accept that perhaps we ought to encourage them to do so. And we should, it's an extension of what I slightly glibly said about the appointment process, and perhaps that's a good question for how conversant are you? We discuss a lot of those things. Should we hold arbitrators' feet to the fire in relation to their green credentials, how they're going to manage an arbitration, in light of the green pledge, etc. In fact, we don't really do any of that other than to ask people if they're overworked and overstressed. That's about the only sort of relevant question. I think there's a very clear dividing line. This is the dividing line between the LCIA and, for example, the Chartered Institute. We leave it to the Chartered Institute to educate and to inform arbitrators and potential arbitrators, and we don't really see that as our role. If you attend an LCIA event or you're a member of the LCIA, we will share knowledge and we will allow you, offer you the opportunity to mix with your fellow arbitrators and to discuss these issues. But we don't really educate in that way and don't see that as part of our role. So we do rely very heavily on the Chartered Institute and support where we can, but I don't think it's really our role to educate. We might encourage and cajole.
Encourage, exactly. That's what I'd rather say, encourage.
Yeah.
And if anybody knows whether there is any training specifically for arbitrators out there, then please share that with us. Exactly. We can all make a good use of that, I think. Otherwise, I think they're just general training possibilities for individuals to make yourself sort of more aligned or aware of cybersecurity, and perhaps ask somebody to help you with a setup who is more knowledgeable on the topic, perhaps.
Yeah.
That's certainly, I guess, the consensus of the panel. But Ruth, your particular pet is also about illegally obtained evidence. But before we really dive into that, also the question is, do you think that an award is enforceable if anybody is aware of illegally obtained evidence has been used, and to what extent?
Well, it really depends what jurisdiction you're then trying to enforce the award in, and every jurisdiction has very different views about that. And so that's a terrible lawyer's answer, isn't it, where I've given an answer without actually answering the question. Maybe I should have been a politician. So it really depends where you're trying to enforce it, and how serious the illegality is, and whether it was crucial to the decision made by the arbitrators. I mean, illegally obtained evidence isn't a new thing. Obviously, in more recent years, there's the risk that evidence has been obtained by hacking, but more often than not, certainly in the context that I've seen, it's phone calls that have been allegedly taped without the other party knowing, or transcripts of meetings, or WP stuff that's, they thought they were all having a WP chat and there's been a sort of recorder in the pocket. I think what's In terms of how you deal with that, certainly as a matter of English law, most of the institutional rules have rules about that give a broad discretion to a tribunal to whether to admit evidence and what weight to give it. The IBA rules, I think, are the only rules that specifically have a power to exclude illegally obtained evidence. That's Article 9.3. But in a sense, you don't really need that because you've got this very broad discretion. What I think is much more interesting when you're counsel or a representative of the parties is whether you object or not. So actually, in some of the really big cases where there's been illegally obtained evidence, it's never come to an issue about admissibility because neither party has raised that. And the reason I think that is because you have to take a tactical decision, whether if you try to get something excluded, it's drawing more light to the piece of evidence. And actually quite often, even on its face, the illegally obtained evidence doesn't claim to be a complete transcript, or the original recording has mysteriously disappeared or is now at the bottom of the sea. If you want to use some of the Rooney, the Rooney type litigation issues. And so often you can get it dealt with by dealing with the weight that you give it. And certainly as counsel, that's how I've dealt with it. And as an arbitrator, it's happened a few times. No one's ever taken an admissibility question about it. They've always just dealt with it on the basis that it's rubbish evidence, it's not complete, there's no guarantee, the underlying recording's not there, etc., etc. So,
have you ever seen it in an award being addressed as illegally obtained evidence?
No, mainly because often the tribunal don't need to go there. They can just say, we're not satisfied that this is a true account of what was said in a particular meeting or on a particular phone call, and then they give an explanation as to why. They will often then quite say, even if we're wrong about that, ... to try and make it as enforceable as possible. But yeah, I think there's a lot of, I mean, particularly now, I mean, Zoom will tell you if you're being recorded, for example. Snapchat will tell you if someone has taken a screenshot of what's on it. But there are lots of other things that you might do that you don't necessarily get told that you're being recorded on. And so I think as more business is done electronically, more of that alleged recording goes on.
Yes, because obviously, yes, from a tribunal's perspective, of course, we would really try not to express this explicitly, as you say, because of enforceability, and also then there comes this criminal aspect into this, which opens another really sort of can of worms. But sort of on the international side, of course, we've got the UNCITRA rules and the Article 27.4, which just gives the tribunal the discretion to or the power to determine the admissibility, the relevance, the materiality of it, and then how much weight they place on it. And I think most rules do that.
Yeah,
and
most of them do.
Yeah.
So in a sense, you don't need a specific rule to tell you that you can exclude it. You can exclude. Admissibility is always for the tribunal to make decisions about.
Yes, which is always a difficult one because we want to have a fair and due process.
Yeah.
So it's a tricky one. Yeah.
In terms of that, there have been some very public cases about the admissibility of evidence, and the sort of general rule as a matter of English law is if you have clean hands, i.e. the party didn't deliberately go out and get it, then quite often it gets let in, but the weight given to it is sort of depending on how relevant it is and what material aspect it goes to. If, however, you have deliberately gone out to do it, you don't have clean hands, and therefore the sort of principles of fair dealing and good faith in arbitration have been broken, and then you're more likely to exclude a piece of evidence on that basis because you don't want to encourage that sort of behaviour.
And Jamie, have you been asked by arbitrators, do they seek guidance from you how to sometimes handle things like that?
I'm sure they do. It doesn't necessarily come across my desk unless there's an issue, potential issue of potential risk to the LCIA itself. I think the casework team will inevitably receive those kind of inquiries. How do we deal with this kind of thing? And I think what Ruth has said is really the answer. You have the power to exclude it if you or to give it whatever weight it deserves, and the rules will back you up on that. So.
Yeah, and I don't know whether there's any rule or any rules that actually explicitly do not give the tribunal the power to do so. I don't know whether.
I don't think so.
No, I've not come across it.
I think most of them give them something. The LCIA gives them 22. So it's there. I think as Ruth was saying, I think one of the things is whether the parties come with clean hands first of all, with where they got information, but also whether, I mean, under English law, like whether it was legally privileged information that you're getting, or how confidential it was, and those sort of factors, as well as public policy. I suppose that goes on to the idea about challenging the award, because does this hack or this illegally obtained evidence actually bring an issue on the integrity of the arbitral proceedings and the award? And of course, that really depends on, of course, when it was known, what was provided to the arbitral tribunal, and all those sort of concerns. So then you might have procedural irregularity kind of issues and enforcement under the which might fall into the enforcement.
And would you have any examples for different jurisdictions that they handle them very differently than sort of the general common sense? Or Robert, have you come across anything like that?
No, not much I can add here, I'm afraid. No.
I mean, certainly the common law jurisdictions all seem to deal with it in a similar way. So the stuff we've seen in Australia is very similar to the stuff that you'd expect to see here, for example. Some of it also doesn't get reported, which makes it difficult, because even though you might end up in court under so certainly in England, for example, you would end up with a court application under the Arbitration Act. It's closed, it's not open court, and it's only ever recorded as X versus Y, and only if, or A versus B, it's only if there's a sort of general point of importance that then would get published suitably and, anonymised. And therefore there is probably law being made that we don't have very clear access to. And that will be the same in some other jurisdictions too.
Which would then, I guess, sort of affect the enforceability of an award afterwards, I guess.
Just depends, doesn't it, on where
Typical answer again,
Yeah.
it depends. Yes, of course, it depends. Yeah.
It depends on whether, when that information was provided, was it actually provided, and the arbitral tribunal have actually made an assessment on it and allowed that admissibility of evidence in, were there fair proceedings? So those sort of issues probably come
I
up.
think it's also whatever the evidence is, whether it's material. I think quite often parties think that a particular piece of evidence is a smoking gun or a really material thing, but actually it might have formed no part of the ultimate decision-making process, in which case there is no reason for the award to be tainted in any way. It was just part of something that happened in the proceedings itself. And I sometimes think it's very difficult for an enforcing court in whatever jurisdiction to try and make that assessment, because they're not party to those conversations. They've only got the award to go on, and some arbitrators are better explaining why they've reached a particular decision than others are. So I think that can make things more difficult too.
Very good, thank you for that. We've got some interesting questions also from our audience. One of them is mentioned, in fact, Julian Wilkins. Is there a role for using blockchain to protect sensitive data? Who can I pass that to? Because I have to say, yes, blockchain, but blockchain for me is sort of, I find that in terms of data protection, I would not be able to.
Well, the problem is it's decentralized, and then you need to know who are going to be in charge of this and who are going to give the permissions on that. So I think it's going to be more complex at this stage. Yes, there have been issues where they think about where corporates have provided an internal system to protect their trade secrets, but I can't see it really in the arbitral process itself, because I think it's just too laborious at this stage. Maybe when the advancement of Web 3.0, we might have more of a decentralized system, and the way that now community building is coming into the plays. But that's a completely different
ballgame again. Yes,
yeah.
Yeah. Have you come across that?
No, I mean, great question, but I think we're a long way off that based on what I've seen most people doing.
And I guess we are not the real experts here on the panel to be able
No.
to exactly foresee that, I guess.
And
or-
The trouble with the blockchain is that it's you need to know how you're going to protect these.
Yeah, no, who holds the key then?
holds
You
the
know,
keys?
as you say, it's
Exactly.
then the responsibility. Who
Exactly.
takes
So are you
that?
going to give it to all the arbitrators?
No, the arbitrators would
It's
not want that
It's
responsibility.
not something that's going to really work.
The law firm
efficiently
wouldn't want that responsibility, I guess, either.
I think
internally, I think.
I would always just come back to what are you trying to protect,
Mhm.
and it's got to be proportionate at the end of the day. Right? If a dispute relates to sensitive IP in the context of a farmer-related dispute, that's very different from if it's a dispute under a share purchase agreement between two private equity funds or something like that, you know, co-investors. The information you're protecting is very different, and then what you might think of doing to protect it obviously varies a lot. So I think proportionality is important here. There are certain baselines that you want to be meeting, but beyond that, what am I protecting? What are we trying to guard against? And using that as a guiding principle is helpful, I think.
Yes, and very interesting. And then we've got exactly the opposite question here online from an anonymous questioner. Since cybersecurity is not effective against state threat actors, should arbitrations go back to paper-only proceedings in defense related to IP and IP disputes? You know, like the spies all go back now to paper and pen, don't they? So should we follow?
Well, I still think this it's chaotic there. I mean, no, I think technology is the way forward. It's just about how do we put the resources in place, and there is a war going on between protecting and putting proper implementation on security measures as opposed to it. But I think all with regard to the green pledge, that's dealing with reducing paper, etc., and actually dealing with what really needs to be done. But you can retract certain parts of the dispute when it comes on to intellectual property, and what can be provided and which parties or which people are actually going to be dealing with the more sensitive category of information as well. So, and this is where you choose your arbitrators to deal with those kind of issues and make sure that they've got certain things in place. But I think for state hackers, etc., I think is a big difference because they probably need to know exactly what's going to happen or where it's going. But I don't think they're going to have to know that there is arbitration going on in the first place.
Exactly.
So I think it's no, I would say no. I don't think paper on it.
Jamie, have you had that
Well,
request?
I think it's very hard to put the technology genie back in the bottle. Probably, certainly, those of you who are familiar with the 2020 LCIA rules, Article 4 makes it very clear that the only means of communication now with the LCIA is via email or other electronic means of communication. And if you want to deviate from that, you need the permission of the registrar. So certainly we've taken a quantum leap towards deploying technology. I also think, of course, that the reality of practice is to rely so much more on technology, be it virtual hearings. We've talked about platforms, but certainly the electronic delivery of documents and the sharing of material, both before a hearing and at a hearing. I think we've embraced technology. I'm not sure that there's any appetite really generally to go back.
Yes, exactly. And we need to also progress because email, in fact, is one of the least secure modes of communication now. So it's not that email is actually secure, it's actually the chat rooms like the WhatsApp, Telegrams, etc., that are safer than email now. But not many people know this.
I don't think the young people use email, do they?
They prefer not to,
The
let's
youth-
say that,
I don't
exactly.
think the youth use it.
Takes far too long to write an email
yeah.
and exactly and do that exactly. And also, I'm just thinking also during the hearing, for example, if you have a virtual hearing, a lot of the communication, especially between counsel and team and experts, is on WhatsApp, for example.
Yeah, and I think even when we've gone back to in-person hearings, most of us now have WhatsApp on the web on a laptop. Because it's much better to be able to type messages than hand up yellow stickies so that everybody knows that your witness has just said something that they shouldn't have done, or there's a point that your leader hasn't put or whatever. You can sort of do it more discreetly.
Yeah.
So I think a lot of that gets used. I think what's slightly difficult is that we've all got very used to keeping our data as we have to for, each individual arbitrator or barrister or solicitor or law firm will have retention requirements to do with their own professional obligations. And one of the things that I think is a bit of a challenge is that nobody really knows what we're supposed to do with things like WhatsApps. If you get, where do we retain them? How do we keep them?
Where's it stored?
Where's
as well,
it
that
stored?
conversation.
If you need it in 6 years' time or whatever, would it still be there? And,
Yes.
and so I think those are other conversations that need to be had around.
Yes, and also
Data security.
it of course then it is in fact Mark Zuckerberg that can read it all, and he has got the right to do so. So you've got to be aware of that. He has the right. Same with Microsoft. Same with Apple when you use Google as well, Google Cloud. Everything. If you use any of these clouds, they have the right to access and read this, and you can't sign it away, and you can't negotiate with them not to.
I'd like to think he's too busy to be that interested in what's in my WhatsApp. So you never know.
No. But
Commodities arbitration, he's desperate to read about it.
yes, but what you have done? We know we had this 6-hour blackout not that long ago with the entire sort of Facebook group. So you couldn't have had that chat then during that time, etc. So I mean, the certainly the world stood still almost on the chats for 6 hours, which is an eternity if you think about it.
It was bliss, wasn't it?
Yeah, exactly. It was fabulous, perhaps, but exactly. And we are sort of subject more and more to the more technology we use, the more subject we are to if it's not working, what do we do then? And I have to confess, I'm one of these arbitrators. I want my bundles as well as electronic documents for hearings at the moment, just in case. At least I can sort of still go via a telephone conference and participate in the hearing and listen to what everybody has said, but I can at least look at my documents in the bundle. What do we do? But that's obviously doubling up and the costs increase as well. Any thoughts on that for?
Well, I mean, in terms of your WhatsApp conversations and everything like that, you can usually export them. So you can actually export them and keep
and archive them.
Well, apart from archiving them, you can actually export them down so you can send them down. Because I've used WhatsApp conversations even in proceedings, court proceedings afterwards. So you can actually download those WhatsApp conversations, etc. Because now we've moved completely digital. I mean, gone were the days where we used to have fax machines. Now we're using GPS data to try and find out that our employees are in a particular location for when you're doing an injunction, etc. So I think technology has moved so forward, but you can export that evidence and keep it down as kind of critical information. But I think one of the things you need to do at the end of the arbitration proceedings is to see how much of that data and information do you really require. Can you delete some of those? How much do you really need for any kind of compliance measures, the insurers, etc. I mean, I think with regard to arbitrators, there's less that they're required to keep as opposed to counsel, for example, because we could have any kind of forms of professional negligence claims, etc., like that we have to deal with. But those kind of issues, I think we really need to look at and we see what do we really need to keep. And after the retention period, I mean, our insurers are now
and where to keep it,
how secure to keep each level, but also the fact that you need to go through a data cleansing process every year, and I think that's part of it, which I'm sure Robert will be fully aware of.
Yeah, I mean, look, if you're keeping something, you don't want to keep it forever because you can't get in trouble for losing something you don't have, right? So the less you've got, the smaller your attack surface area is really, and the fewer your obligations are in respect of that information. I think what we're also talking about here is a little bit of operational resilience, right? We spoke about a little bit earlier. How do you make a digital arbitration operationally resilient? It just poses different challenges to when everyone's all getting together in a room. The physical bundles only, what happens when you go wrong? You mentioned costs about additional physical bundles. Negligible really for most large arbitrations, sorry to say, but so I don't think it really factors in for many cases. It's just an additional headache of having to produce a physical bundle.
Exactly.
That won't fall on the arbitrators, to be honest.
Yeah,
So
yeah, exactly, because that's the case now, but now you can see what our sort of motive for that is. But we've got one more question. Is the use of sandbox systems the solution for future arbitrations? The question, I have to admit now, it's, I know I used to know what sandbox systems are, but right now on my memory fails me there. Have you heard of sandbox systems?
So I'm assuming the question is sort of directed at the idea that you have a system which hasn't got outward connectivity, or the outward connectivity is very limited.
If you exchange, if you upload documents into a document repository, you already open it up. Same with the LCIA system. If you now register your cases online, the system has opened a door. Yeah.
So
how would that work?
It is technically possible to have something more secure, but you know, look, I've not seen anyone do it. It does come up. It does come up in the context of e-discovery exercises where certain service providers will offer on-premises hosting of data, and actually you can have an entirely on-site review of systems that aren't internet-facing at all. Struggling to see how it plays out in the arbitration context, but you know, maybe people have ideas.
It's difficult to see how it would practically work, and I think it all goes back to Robert's point about proportionality. I think there may be arbitrations where the information that you're dealing with is so incredibly sensitive that you think it's a real risk of being hacked. I think a lot of the arbitrations that go on aren't that interesting to other people. It's not that people think that there is some data there to be exploited.
No, it's if it's just made to make money, isn't it? To ransom and then get the ransom or something. I think sort of maybe to be sort of just your last thoughts, share your last thoughts on the topic to draw to a close. We've definitely covered all the questions that we've had from our audience. Should we do you last? Perhaps then you can also the closing ones.
Yeah.
So for me, it's very clearly the mindset, and we need to sort of be much more aware of it. But Robert, what would you say?
Yeah, I think I've just come home 2 points mentioned earlier. One is I'll come back to proportionality. Turn your mind to it. Try and be proportionate about it. I think if people try to boil the ocean, for want of a better phrase, that's when people can get a little bit put off and then actually take a step back. And then I think the other point is it's got to be a collaborative journey. No one can do it on their own. And I say that to anyone I'm talking to this topic about, whether it's in the context of arbitration or a joint venture or anything else.
Ruth?
I'd say be proactive about it. It's a little bit like when you talk to people before they sign contracts, they really need to think about what the governing law is at the beginning of the negotiations, because if they think about it at the end, sometimes all the pre-negotiation is part of the construction and part of it isn't. I think cybersecurity is something that needs to be thought about at the beginning of the arbitral process, and then it needs to be a sort of collaborative effort.
Very good. Shobana?
I would say that in addition to these, next one I would say is don't think you have to be a technical genius to have general cybersecurity. I think it's like you can learn the basics of cybersecurity and keep updated on that. I think you have to do it now. But essentially it's like learning to drive a car as opposed to knowing how the engine works in detail. So I think you can, don't be too scared about, oh boy, that's going to be very difficult. I think there are simple guidelines out there that really can assist you.
Yeah, and I think I echo that. I mean, I feel slightly like I may appear a bit evasive about what the LCIA might do for you as arbitrators, and rely very heavily on the rules that suggest that it's really down to you and the parties. And really, I think it is up to the arbitrators to keep themselves educated, keep themselves abreast of issues, to make sure they themselves are insulated as far as possible from these issues, and that they raise them at an early stage in the proceedings, so that it is highlighted. As parties, bear in mind if you're appointing, or if you're nominating a co-chair, for example, a co-arbitrator, bear in mind those things. Bear in mind the likelihood or the possibility that this might be the subject of an attack, and keep that in mind when you're choosing your tribunal.
I think everybody is still an answer about our poll, and it's 100% no, they're not aware that they've been hacked, which is a very different result to last time when we asked, which in fact 19% of the audience at that time said they were aware that they were hacked. So I think they've probably become more sophisticated, the hackers. That's my conclusion.
Obviously, your seminar last year did the trick. I think really to wrap things up, it falls to me to just say a few words. The LCIA is as ever delighted to have the opportunity to co-host this event with the Chartered Institute. It is a great opportunity for us to mix with the arbitrator community, people who are on our list or who hope to be, and to discuss some of these issues which are really important. And we've enjoyed that opportunity once again. Personally, for me, this has been a great treat. Last year, in the same event, I tested positive for COVID at 3 o'clock in the afternoon, and was unable to attend, but actually was presented to the audience via a screen about 4 times the size of that hung above everybody's head, and I was the only one to be virtual, and was in the first throes of quite a nasty dose of COVID. So I'm not sure I looked great. I looked at the video and wasn't very happy. So really, I think we should all thank Karina for her, well, firstly for marshalling everybody to this subject and for galvanizing interest in the panelists and in our audience, but also for moderating this evening, which has been much appreciated. And of course, my fellow panelists, always a pleasure to be in the company of people who actually know about their topic, and to share in their views. I think we should thank Quadrant for hosting us. Sarah, in particular, who's hovering in the middle of the room, has been a Trojan in terms of organising this evening. But it's always great to have a lovely venue right in the centre of the heart of legal London, which makes it easy for everyone. And I think we all appreciate that. I've been asked to tell you that following this evening's event, I was going to say festivities event, drinks will be served in this room. I think we did speak, obviously, as panelists about whether we would go ahead this evening on the basis of the news last week and the fact that technically we are a subdued city in mourning, and we await the arrival of the Queen either later tonight or tomorrow morning. So we would like to go ahead with drinks. We'd like to give you an opportunity to mingle, but obviously always with the caveat that I think nobody is expecting us to get too raucous. So, okay, thank you.
Thank you very much.